I'm very pleased, especially to have the delegates from Myanmar and from China. Parliamentarian from Myanmar and a very outspoken activist who I think we can hear him share what actually happens at the hand of police in China. And to share, I think this is for better sharing amongst ourselves to find out, first of all, what the facts are and what we can try to do to bring about changes. I think you'll be given copies of my speech later on, but so no need to take extensive notes. But if you want to write down things where you might have questions, or those areas, which I hope where you will have further follow-up discussion in the days to come. As we begin this second meeting, let us start with a short reflection on the overall aims of the project to promote the Convention Against Torture, CAT, and our progress in working to prevent torture in Asia. In this regard, there have been some historically important achievements this year in the Asian region. The adoption of a law criminalizing torture in Bangladesh naturally should receive pride of place. During our last meeting, we learned that there was skepticism about the success of the private member's bill for criminalizing torture, which was then before the Bangladeshi parliament. However, as we meet now, this bill is already a law passed without any opposition. The title of the new law is the Torture and Custodial Death, in brackets Prevention, close brackets, Act 2013. It was passed on October 24th, 2013. The passing of this law has an interesting background, which is very relevant to us as we are persons who have taken a voluntary interest in the task of eliminating torture from our countries. The initiative for the new law in Bangladesh and all the work that went into promoting this legislation came from voluntary efforts of Mr. Sabir Hossain Chowdhury, an MP from Bangladesh, who contacted the Asian Human Rights Commission with a request that we assist to draft a bill criminalizing torture that could be placed before Parliament. The Asian Human Rights Commission immediately took the initiative to draft the bill. Bijo had a large role to play in this, as with the assistance from Basil, input from Basil, and we made this draft available to this enthusiastic parliamentarian. He placed the bill as a private member's bill. He also took numerous steps for internal lobbying, as well as external advocacy, to bring the bill to the attention of the government. The Prime Minister later placed the bill before a select committee, which thoroughly discussed the issue after making some amendments and recommended that the bill be placed for debate. Meanwhile, the Asian Human Rights Commission carried on with parallel promotional work, and soon several civil society organizations in Bangladesh joined in. Of these, a local organization, AHRC, which is also represented at our first meeting, deserves special mention for their efforts in promoting this legislation. What comes next for Bangladesh will be discussed later in this speech, together with the challenges faced in other countries. Suffice to say that at this moment, Hong Kong, Sri Lanka, the Philippines, and Bangladesh are the only places in Asia which have legislation criminalizing torture. There have also been encouraging developments elsewhere. For example, in Pakistan, a prepared bill has now placed before a former judge for review, after which it will be presented to Parliament. This initiative in Pakistan also demonstrates what volunteers, including civil society organizations, can achieve in promoting legislation on human rights issues. Within a short period of 2 years, a large number of human rights organizations responded to the call by the Asian Human Rights Commission to draft legislation criminalizing torture. At that time, I make it aside here, Basil traveled together with Basir and met quite a few groups in Pakistan, and their enthusiastic response was very good in helping to promote the adoption of this law. They were able to convince both of Pakistan's leading political parties to give priority to the passage of this law. Several ministers of the former, as well as the present government, as well as other parliamentarians, have supported this call from civil society organizations. The bill is currently being discussed in Parliament. We hope that when we meet next year, we will be able to report that Pakistan, too, has also adopted a law against torture. In both Nepal and India, bills criminalizing torture have already been placed before their respective parliaments. There are important civil society lobby groups pressing for the adoption of these laws. The Asian Human Rights Commission has contributed to the promotion of these bills in both countries. While we note that these extremely significant achievements have taken place, we must also recognize that some of the central problems obstructing the efforts to eliminate torture are still there. Some skeptics even go to the extent of saying that while laws are passed, the actual implementation of these laws will never happen. While we would like to dismiss such skepticism, it is quite sensible on our part to take a look at the actual situation and the seeming absence of political will on the part of many governments to take the requisite steps to eliminate torture, even though these governments condemn torture and ill treatment as inhumane practices unbecoming of any decent nation. When we take a closer look and make a closer examination of the obstructions to the elimination of torture, it is obvious that the major problems lie within the criminal justice system and the actual ways that they function in our Asian countries. As was noted during our meeting last year, the frequent, widespread use of torture in many Asian countries is almost the necessary result of the very primitive and backward nature of the criminal justice systems in these countries. The use of the fist, the boot, and far worse methods of torture and ill treatment are in fact tacitly approved methods of dealing with accused persons. Governments don't invest much in criminal justice. While issuing statements that are pleasing to the ears of the international community, governments do not make the necessary investments to provide modern systems of investigations into crime. Purported investigations rely solely on the torture and ill treatment of suspects. In fact, a heavy reliance on torture and ill treatment is considered a convenient and inexpensive method for collecting information. These practices contravene the basic axiom of criminal justice. Namely, it is better for 100 criminals to go free than to wrongly punish one innocent man. And inverted too, it is better to torture and ill-treat 100 persons in order to catch a single criminal. A book published earlier this year, Narrative of Justice, which narrates 400 stories of torture victims in Sri Lanka, almost all of whom were innocent. The use of torture and ill treatment reflects an irrational approach to criminal investigations that still prevails in many Asian countries. Therefore, perhaps it is important for the legislators attending this meeting to try to address this overall policy problem relating to criminal justice. The sheer irrationality of the prevailing system should be exposed so as to make it possible for legislators and the executive to adopt improved policies backed by realistic budgetary allocations that would make the system more rational and efficient. What makes the issue of backwardness of the criminal justice systems more complicated is the increase in organized crime, as well as the use of more sophisticated weapons by criminals. Experienced criminals and those who are organized know how to avoid torture, as they often bribe police and thus remain free. One consequence of this aspect of the system is that large numbers of innocent persons are arrested, tortured, and charged as substitutes to replace the actual criminals who have carried out those serious crimes. A study of torture cases shockingly reveals that officers who have arrested victims know from the very start that these replacements have no link whatsoever to the crime in question. However, either because the police cannot solve a particular crime, or because they don't want to arrest a person that they think or even know did commit the crime, officers often decide to implicate an innocent person. Naturally, an innocent person who has been arrested and accused of committing a crime would deny this involvement. Therefore, the only way to get that person to confess to committing the crime is by way of torture and ill treatment. This is happening on a large scale in many Asian countries. Documentary evidence of this reality has already been done in several countries. A further aspect of organized crime involvement is the police-criminal nexus. In Sri Lanka, for example, a deputy inspector of police has been arrested in regard to the contract killing of a wealthy businessman. And perhaps we can hear similar examples from other countries. It has also been alleged that this officer, along with a few subordinate officers and some criminal gangs, have been engaged in a series of crimes over a period of several years. These crimes include murder and the illegal disposal of bodies, as well as various financial transactions that have benefited some police officers as well as the criminals. The government neglect of the policing system is the actual cause of this degeneration of the system. It is starkly clear that one of the primary needs in many Asian countries is thorough police reform. Such reform is also a primary requirement of, I would submit, economic development. Can there be much incentive to invest in an environment where the police have a reputation for being linked to crime and where corruption is rampant? Is the policing problem not also an economic problem that needs to be addressed by both legislators and the executive? To ignore this issue is to invite a great peril. One of the frequent questions that is asked about the prevention of torture is, who will investigate complaints of torture and ill treatment? Quite naturally, there is a tremendous distrust that the police or army officers, who also are involved in torture, could properly investigate or carry out an impartial inquiry into torture perpetrated by their own respective colleagues. Given that some higher-ranking officers are complicit in the wrongdoings of their subordinates, and given the fact that some high-ranking officers have been called to investigate torture and ill treatment, they have attempted to discourage the complainants or even intimidate and threaten them. So can these officers be trusted to carry out proper investigations? On the other hand, organizations like the Human Rights Commissions or the national institutions do not have the requisite resources or power needed to properly investigate allegations of torture and ill treatment. Most of the laws relating to national institutions authorize functions of a civil nature. Further, it is not within the mandates of such organizations to investigate crimes. Besides, the appointment of persons to these human rights institutions, as well as their removal, are both susceptible to direct political pressures. Thus, these institutions, in terms of establishing a permanent institutional framework for the implementation of laws criminalizing torture, are unsuited to the task. Who then can investigate complaints of torture and ill treatment? When the policing institutions reach the proper standard, the police themselves, using modern techniques and procedures, under the ultimate supervision of the judiciary, will then be able to properly investigate torture and ill treatment. Excuse me. In the process of modernization, the policing institutions will develop a proper supervision and discipline, as well as the capacity to investigate itself. The issue, I think, right now for most of us is what can be done about the complaints regarding torture and ill treatment in countries that have notoriously substandard policing. Unless a practical solution to this problem is found, achievements in related areas, including good legislation, will not be of much value to the public, particularly the victims of torture. Thus, in this transitional period, before substantial changes have been achieved, ways have to be found and developed to conduct credible, independent investigations into cases of torture. We may look at some concrete experiences. In the year 2006, there was pressure from the United Nations human rights agencies, as well as widespread criticism by NGO groups and others about the prevalence of large-scale torture in Sri Lanka. The government responded by investigating complaints of torture. This proved quite effective, as long as those measures were implemented. The method used was that the Inspector General of Police, or the Attorney General, would refer complaints of torture to a special unit of inquiry of the Criminal Investigation Division, CID, for investigation. The special units, called SIUs, usually consisted of officers whose capacity and integrity had been recognized. Within a period of 2 to 3 years, these SIUs investigated a significant number of cases, in all about 60 cases. And they found that there was adequate evidence to prosecute, in the overall number, they found in 60 cases, there was adequate evidence to prosecute officers. The files of these cases were presented to the Attorney General's Department with recommendations for prosecution. Thus far, this is the only example in Asia where effective measures were taken for the investigation of torture and ill treatment. Unfortunately, this approach was abandoned in Sri Lanka due to pressures from the police and the military, which reacted strongly against the investigations and subsequent court proceedings. Although unfortunately, these investigations lasted for only a short while, this experiment proved that ways can be found to establish a special group of investigators with competence and integrity to conduct investigation into complaints of torture. I might pause here, it's not in my written speech, but this indicates that not all police officers support torture. There are people within the system who would like to do away with it, but for other reasons, other pressures, and perhaps you can discuss this, why they are not allowed to carry this out. Because as we saw, it was successful when it was allowed to go on for a number of years. Whether or not this will happen, again, will depend on the political will of the government. In turn, the political will of the government, at least to some measure, will depend on the extent of pressure from civil society. There is an increasing number of civil society organizations committed to the documentation of torture, as well as providing assistance to torture victims by way of legal, medical, and psychological assistance. Committed members of civil society can help to create the local and international pressure necessary to make governments aware of the need to eliminate torture. In this regard, conscientious legislators can play an important role by helping to mobilize civil society, your political base. I hope that during this meeting, this all-important issue will be a subject for your deliberations. Associated with effective investigations is the need to provide protection for the victims, as well as those human rights defenders and lawyers who assist the victims of torture. And perhaps in this regard, Mr. Tang can say a little bit what's happening in China. A victim who makes a complaint about torture puts himself at risk of being harmed. The particular officers who use torture usually do all they can to stop victims from pursuing their complaints. The methods adopted vary and include intimidating and harassing victims and their family members, fabricating false charges, as well as offering monetary compensation and other incentives to try to get the victims to withdraw their complaints. And any of this behavior, if any of this behavior was done in regard to other crimes, it would be considered an interference with the administration of justice, which in itself is a crime. However, when the police and military are accused of torture, this interference with the administration of justice is usually not pursued. There have been examples where the alleged perpetrators of torture have even killed the victims who have made the complaint. Thus, this vital issue of witness protection, which is accepted as a necessary part of the administration of criminal law, should be in the forefront of the minds of legislators and civil society. Is there any justification for delay in passing and implementing witness protection laws? Another area of great importance is the welfare of victims. Today we are more aware than ever of the crippling nature of torture and ill treatment. Conditions such as acute shock and post-traumatic disorders, which have become part of our daily vocabulary, are caused not only by accidents, but also torture. The role played by psychologists needs to be better recognized, not only from the point of view of treating and assisting victims with their recovery, but also the role they can play in the prosecution of torture and ill treatment. Some psychologists are already trying to assist victims who are dealing with these problems. Other psychologists have been willing to assist victims by helping them to articulate their psychological condition as testimony. In other words, it can be put into evidence that be used in court. Again, I suggest this is an area that you should discuss, both in terms of the needs of the victims, as well as helping to create awareness in our societies. Hopefully this will lead to the allocation of much needed resources. All this work will require more alert and at first more frequent judicial interventions. Traditionally, the criminal bench of the judiciary has only been used to deal with ordinary criminals. When state officers, particularly police and military officers, are brought before the courts, the judges often feel caught in a very complex dilemma. These are guys who are part of our team. Some judges who consider police officers as key players in maintaining law and order and often take a sympathetic view of these accused officers. Some judges even think that the punishment of these officers might have a chilling effect on other police officers, which might adversely affect the entire criminal justice system. I would submit that if effective torture prevention is to take place, a very essential component is judicial education. Judges need to learn the role they can play, first to prevent torture, and second, to demand the developments of the kind of police work which meet the highest standards. In most Asian countries, it would not be an understatement to comment that most judges have not played their respective role in trying to achieve the all-important goal of eliminating torture. Some would even say that the cold-heartedness of judges is a contributing factor to support the widespread practice of torture. Judicial education must necessarily include education on basic human rights and modern jurisprudence regarding torture and ill treatment. Just last week, the USA-based group called Institute on Medicine as a Profession released a report which stated that medical professionals, quote, help design, enable, and participate in torture and cruel, inhumane, and degrading treatment, unquote. And this was done on detainees. One of the authors of the report stated, quote, it's clear that in the name of national security, the military trumped the Hippocratic Oath, and physicians were transformed into agents of the military and performed acts that were contrary to medical ethics and practice, unquote. In Asian countries, doctors sometimes stand by when persons are being tortured. More frequently, doctors assist police officers who try to cover up torture by performing so-called examinations of the torture victims and then preparing false medical reports. This is an area that should be more closely examined by the medical profession. Perhaps it should also be subject that parliamentarians may wish to investigate or at least discuss at this meeting. Excuse me for a minute. I'm grateful for your indulgence. It is in a very interesting book on killing, which Mr. Basil Fernando found for me and gave me a copy. A retired U.S. Army Lieutenant Colonel by the name of Dave Grossman, who is also a psychologist and taught psychology at West Point, refers to, quote, compelling data that indicate that the singular lack of enthusiasm for killing one's fellow man has existed throughout military history. I'll read that quote again. This is by a military man talking about soldiers. Compelling data indicate that the singular lack of enthusiasm for killing one's fellow man has existed throughout military history. And he gives examples from the time of Alexander the Great up until the Vietnam War. A study conducted by S.L.A. Marshall, who is a senior officer in the First World War, and then it was a historian in the Second World War, found that in World War II, 80% to 85% of U.S. soldiers did not fire their weapons at the enemy. Did not fire their weapons at the enemy. And of those who did fire their weapons, many shot high. Marshall is quoted as noting that when faced with the responsibility of killing another person, if it is possible to turn away a soldier, and I quote, at this vital point becomes a conscientious objector, unquote. Grossman concludes, quote, there is a force within mankind that will cause men to rebel against killing, even at the risk of their own lives, unquote. Yet soldiers do kill. Grossman notes in his book that there are sociopaths in our society who, when they become soldiers, and in quote, sociopaths who will kill without regret or remorse, unquote. But he goes on to note that those individuals only comprise 2% of all the veterans. And there's documentation on this as well. Grossman discusses the increase in murders in the U.S. and discusses how, through the senseless violence depicted in movies and now video games, quote, we as a society have become systematically desensitized to the pain and suffering of others, unquote. One of Grossman's most interesting footnotes is his note that after the My Lai massacre in Vietnam, the U.S. Army instituted a program of mandatory annual training about the Geneva Convention and related law. And Grossman notes, quote, in this training, soldiers are taught which orders are illegal and how to disobey illegal orders. And I emphasize that last point, how to disobey illegal orders. Grossman then comments, quote, this may be the first time in history that soldiers have been taught to disobey orders. We can discuss how these insights can be applied to torture by police officers, military officers, and intelligence officers in our respective countries. I would guess that, as with soldiers, there are only about 2% of police officers who can torture without remorse or regret. Should we discuss legislation that requires all police officers to participate in annual training programs that present the clear guidelines set out in the International Convention Against Torture, as well as legislation for those countries who have such laws? Can we also discuss a possibility of passing legislation that will encourage police officers to be whistleblowers and reveal specific cases of torture being done by their fellow police officers? Can the legislation for the protection of witnesses also offer protection for those police officers who speak up and are prepared to give evidence in court? While each country has to pass their own legislation excuse me, and establish their own institutions to prevent torture, I would submit it is also necessary for the international community, including UN, United Nations agencies, engaged in human rights, to take an active part in the promotion of police reforms. The goal is to transform police agencies into modern institutions that abhor and prevent the use of torture and ill treatment. There are ongoing activities among NGOs, such as by the Asian Alliance Against Torture and Ill Treatment, and groups of lawyers who are documenting instances of torture to enable them to speak out against the use of torture and to urge institutional changes that will prevent the widespread use of torture. Allow me to diverge briefly about another point. There are troubling signs around the world that many political leaders are increasingly searching for excuses to allow them to torture persons, as well as finding justifications for not investigating or prosecuting those persons who are alleged to have committed torture. The most common rationale that is being used is what? What's the most rationale that you hear, most commonly cited rationale for using torture? It's in the papers almost every day. War on terror and national security. National security we hear, and within that is the war on terror. I think that's, see it regularly, but also this. We can discuss this more. All the various things that are used to justify. There are many examples from around the world that can be given. I'm originally from the United States. I've been in Hong Kong since 1968 and visited most countries in Asia in the early 1970s. But I would like to cite a few examples from the USA, which often, usually correctly, condemn specific human rights abuses in other countries. When he was a candidate, Barack Obama condemned waterboarding and other interrogation practices, which he considered amounted to torture. Obama stressed the importance of upholding the rule of law. No more, and I'll give you a quote, this is a quote from Obama as a candidate. No more ignoring the law when it's inconvenient. This is not who we are. We will again set an example for the world that the law is not subject to the whims of stubborn rulers and that justice is not arbitrary. This quote I found in the book With Liberty and Justice for Some by the author Glenn Greenwald, who was one of the 3 newspaper reporters to whom Snowden turned when he wanted to do his whistleblowing. And I'm indebted to the research and insights of Greenwald for the material I will cite below, giving the page references, and you'll see them in when you get this copy, to that same book. And I highly recommend the book. It's very well put together. In a June 2000 speech, Eric Holder, who would become President Obama's Attorney General, stated in unambiguous language, "Our government authorized the use of torture and authorized the use of procedures that both violate international law and the United States Constitution." General Barry McCaffrey, in a 2009 interview, very high-ranking general, stated, quote, "We tortured people unmercifully. We probably murdered dozens of them during the course of that torture, both the armed forces and the CIA." Human Rights Watch, unquote. Human Rights Watch researcher John Sifton claims, quote, "Approximately 100 detainees, including CIA-held detainees, have died during U.S. interrogations, and some are known to have been tortured to death." Now, these figures don't include those who were taken away to other countries for torture. However, after he was elected, Obama took up the mantra of recent presidents since Gerald Ford. Quote, "We need to look forward as opposed to looking backwards." We need to look forward as opposed to looking backwards. I don't want them, namely the officials accused of torture, to suddenly feel they've got to spend all their time looking over their shoulders and lawyering up, means getting lawyers to assist them, unquote. As you are aware, the Convention Against Torture states very clearly, no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency, may be invoked as a justification of torture. An order from a superior officer or a public authority may not be invoked as justification for torture. Even for those who are not lawyers, that message is unambiguous. In January 2009, Manfred Novak, the UN Special Rapporteur on Torture, announced, "Judicially speaking, the United States has a clear obligation to bring proceedings against top government officials who authorize techniques that under international law are considered torture." In a later interview with Greenwald, Novak said, quote, "Whoever practices torture shall be brought before an independent criminal court and be held accountable. That is, the torturer, him or herself, and those who are ordering torturing practices, or in any other way participating in the practice of torture. This is a general obligation, and it applies to everybody. There are no exceptions in the convention." Then Greenwald emphasizes, "A criminal investigation of torture allegations is thus mandatory under both the Geneva Conventions and the Convention Against Torture. Refusing to carry out such an investigation is itself a crime, a new violation of the law, separate from the original acts of torture." In other words, President Obama, by not carrying out the investigations, is guilty of a crime. President Obama, a former constitutional law professor who clearly knows the law, not only refused to initiate any investigations into the allegations of torture and those who committed torture or who ordered it by U.S. employees and officials, but he also took a wide variety of measures to obstruct investigations, and he even interfered in court proceedings. A few examples. Quote, "Just to be extra certain that Holder would not initiate criminal proceedings against Bush officials, the White House continued to pressure the Attorney General even after Obama had publicly acknowledged that such pressure was inappropriate." Number 2, White House officials made efforts, quote, to forestall any formal inquiry into Bush's torture regime that might be carried out by a congressional committee, unquote. In other words, they put pressure on the members of Congress. When prosecutors in Spain initiated a criminal investigation of former Attorney General Alberto Gonzales, he was Attorney General under Bush, and 5 top associates in regard to the roles they played in the torture of 5 Spanish citizens held at Guantanamo, not only did Obama speak out against the investigation, but we know, thanks to WikiLeaks, that, quote, Obama's State Department warned Spanish authorities that any efforts to hold Bush torturers accountable would, as one cable put it, not be understood or accepted in the US and would have an enormous impact on bilateral relationships, unquote. Although in 2009, an Italian court found 22 CIA agents guilty of kidnapping an Islamic cleric in Milan, the administration has actively protected these CIA agents from any extradition attempts by the Italian authorities. Here's another quote from Greenwald. Number 5. The Obama administration also undertook extraordinary efforts to prevent courts in Britain from investigating claims of torture by Binyam Mohammed, a British resident who was incarcerated at Guantanamo for 6 years without any charges ever being brought against him. And then he was released. This example deserves a bit more detail. Mohammed lawyers sought discovery of, quote, notes taken by British agents during discussions with CIA agents who detailed to the Brits what they were doing to Mohammed. A British High Court ruled in his favor, finding that Mohammed was entitled to obtain the documents to prove that he had been tortured in American custody. As part of the ruling, the British High Court prepared a summary of the notes in question. But just when the ruling of the High Court was about to be released, and the world was to relearn the details of Mohammed's abuse at the hands of his American captors, the British government warned the court that British national security would be severely jeopardized if these details were disclosed, unquote. The British government specifically said that if the courts released the information, quote, U.S. intelligence agencies would no longer pass on to Britain any information about terrorist plots aimed at British citizens. You get that? So if they reveal the information, the U.S. will not tell them anymore about any terrorist plots, unquote. It would appear, this is the reference, the conclusion I draw, the inference I draw from that, it would appear that the Obama was not only in breach of CAT, Convention Against Torture, and the U.S. Constitution, but he was prepared to not disclose information about terrorist plots. Would that not, in effect, make him helping and aiding and abetting terrorists? Whenever we hear of attempts of any kind by any person to defend the use of torture, we need to remember the clear message of the Convention Against Torture. Torture is never permissible for any reason. I would now like to return to the main theme, namely the use of torture by police officers in many Asian countries as an ordinary means to attain the objectives they have set. That objective is to force persons to state what the police want those persons to say. The police officers attempt to justify the torture they employ as a means of carrying out their investigations. These police officers must learn. First, it is always first, that it is always wrong to use torture, and second, that proper police investigations do not have to rely on torturing people. In many Asian countries, there are not yet laws in place that make torture illegal. If torture should never be used by anyone, should not the first step be to pass laws making torture illegal? Once laws making torture illegal are passed and in place, the requisite structures to ensure a strict implementation of those laws must also be put in place. I submit to you that these are some of the more important challenges facing those concerned about working to eliminate torture. I hope that your discussions will bring greater enlightenment on all aspects of this all-important issue, and that those discussions will someday bear much fruit. Hopefully, at a future third Asian Meeting of Parliamentarians and Human Rights Defenders, we would have more positive stories to narrate and more achievements to share. So I wish you best wishes for a fruitful discussion during these few days.